So good morning, everyone. Welcome to the session on compulsory purchase powers. We're going to do a few sort of introduction slides first, and then I'll be handing over to Michelle, who will be sharing her experience with you this morning. We'll then be coming back for a Q&A session at the end. So next slide, please, Michelle. So my name's Claire Giles. I'm the head of compulsory purchase at Homes England. I'm delighted to welcome you to the summer learning programme, and welcome back to any of you who shared a session with me in the winter last year on the same subject, although a slightly different vibe in terms of look and land assembly that time. So the programme, we try to offer a series of knowledge sharing sessions on topics that you've told us that you find interesting. And likewise, at the end of this session, do feel free to drop any sessions that you would like to hear about in the future to us in the chat or after the event, and we'll try to facilitate those for you. Today's event is a canter through legal tips and trips, which hopefully will be helpful to those of you who may be considering using your compulsory purchase powers. Next slide, please. So the Summer Learning Programme is brought to you by Homes England's Local Government Capacity Centre, and our mission is to assist the strategic plan of Homes England, which has just been released, as I'm sure some of you will have seen in social media and elsewhere. And the CPO is particularly important to us in achieving our mission around regeneration and housing delivery and creating high quality homes and thriving places. Next slide, please. I won't go through this slide because it's busy, but it will come out to you in the slide deck. And as you can see, these are our new strategic objectives, and compulsory purchase will play into achieving a lot of these objectives through Homes England's own powers, but also perhaps by assisting some of the local authorities and other partners to use their powers as well. Next slide, please. And the Local Government Capacity Centre, we tend to develop, curate and hopefully provide to you information that you do need to know in terms of helping you to build your capacity and skills to deliver on our plans and your plans as well in terms of housing delivery and regeneration. And at the end of the session, I will be putting up a slide about an exciting new development that is coming to the Local Government Capacity Centre. This is the agenda for the day, so I'm going to be very quiet in a moment, pass over to Michelle. She will be giving the presentation in terms of tips and trips and going through some case studies where perhaps things didn't go quite as well as were planned. We'll then be coming back for a Q&A at the end, which I'll be getting the questions from the chat function from, and then at the end, revisiting the poll, just some final thoughts and closing over. So Michelle is a very, very well regarded legal expert in compulsory purchase matters. She has many years of experience and many successful orders under her belt. So Michelle, without further ado, over to you.
Thanks very much, Claire, and good morning and welcome to everybody. So as Claire outlined in the introduction, for the next hour, I'm really going to focus on some of my top 10 tips for pursuing a compulsory purchase order. I'll then look at some case studies as to how they have played out in practice before briefly touching on the law reform agenda that's going through at the moment. So fundamental top 10 tip, which is really the overarching case for a compulsory purchase order, and a local authority or other body should not be even considering a compulsory purchase order unless if they don't think this test can be met. But there must be a compelling case in the public interest for a compulsory purchase order to be made, and for the Secretary of State to confirm it at the end. That's enshrined in guidance. I'll be referring throughout the session to the CPO guidance, which is the DLUC compulsory purchase guidance on CPO and quick short down rules. That there'll be a link to it in the end of the slides. But that is effectively your CPO Bible, so to speak, and the key resource to go back to in addition to the particular authorising statutes. So the essential question is, will the public benefits that are associated with your scheme proposals, will they outweigh the interference with private rights that you will inevitably have by taking land away from people compulsorily? Most of the CPOs that get promoted are under Section 226 of the Town and Country Planning Act 1990. They're often called Regeneration CPOs. And so where you're dealing with public benefits, what you've also got to bear in mind is you have to satisfy and the economic, social and environmental well-being tests as well, because a local authority should not exercise its CPO powers in the Town and Country Planning Act unless they think that the development, redevelopment or improvement of the land, which will be facilitated by your CPO, is likely to achieve those objectives. So where I often recommend that people start if they're looking at CPO is get a piece of paper out, list on one side all the public benefits which you expect to deliver by your proposals, but then on the other side go through all the reasons why they could be undermined. Are they compelling benefits? Are they deliverable? Because it's all very well having objectives, having aims, which may well be backed up by planning policy and other guidance, but if there are constraints to delivery, then it's going to undermine your overarching justification for CPO. So be cautious about this rather than rose-tinted glasses. The next absolutely critical question when I'm first instructed on CPO that I always ask is, what is the scheme? Because ultimately, CPO is all about scheme delivery. It's not an end in itself. It's a tool to deliver a scheme. So you've got to identify the scheme at the outset rather than jump straight into we need CPO without giving consideration to what it is you're seeking to achieve. And this is really important for a whole host of reasons. You have to be able to justify the inclusion of all the land and the rights in your CPO and why they are needed for that scheme. And it can't be a nice to have, it has to be essential. The guidance is clear that you have to have a clear idea how you intend to use all of the land that you're proposing to acquire. Your Section 226 Town and Country Planning Act tests equally require you to demonstrate that the land in your order is needed to facilitate the carrying out of development, redevelopment or improvement, i.e. your scheme. So it's imperative that this is nailed down at the outset before you get too far through a CPO process. But it also follows that you've got to be able, if you consider that the land is essential for the scheme, you've got to be able to articulate what the implications are for the scheme and for your ability to realise the public benefits and well-being benefits if any of the land is not included in the CPO. And that's harder to articulate, but it's really important, and you have to, it will be necessary to resist objections. Another aspect of scheme that's often overlooked if CPO gets too much of a head of steam too early on in the process is the need to consider alternatives. This is a fundamental thread throughout planning law, not just compulsory purchase, but what alternatives have been or will be considered that might achieve the same scheme objectives. So if you're looking at estate regeneration, for example, have you considered whether refurbishment is more appropriate rather than demolition? Have you considered whether a hybrid approach is appropriate? How have you arrived on the particular site and the location for your scheme? Or if it's a highways, for example, how have you arrived at that route, or how will you? Are there other suitable locations? Also, what's critically important is, have you consulted on the scheme and on this site selection and the route selection? And if so, how have you dealt with, or how will you deal with things like requests from those key stakeholders and from affected parties for changes to the scheme and reporting them? It's really important that you have a robust approach and objective engagement early on in your scheme evolution, and rather than presenting a fait accompli. Otherwise, you're going to find it very difficult to demonstrate that you have taken into account the paragraph 106 of the guidance as to, could the purpose that you're seeking to achieve be dealt with by other means? And that may involve having to consider proposals that have been put forward by third parties. So, for example, if you're dealing with a town centre scheme, you may get somebody saying, well, you don't need to acquire my land to achieve your objectives. There's a clear planning policy framework. I can deliver this office with, ground floor retail, for example. So you've got to put these things to the test and not dismiss them too readily. If you've got a large scheme, such as the opportunity areas or a major comprehensive planning policy allocation, then you need to think about whether the scheme is really a phased scheme, maybe delivered over sort of 15 years, for example, in which case will one CPO be justifiable if you don't know what's actually going to happen on those later phases and you don't have the planning in place or you don't have the funding in place. So you've got to consider the boundary for your CPO early on in your strategy and be aware that if you are going to have multiple CPOs, each CPO has to be justified on its own right. So the public benefits which will arise from the acquisition of land and its development of that particular parcel is what will justify your CPO. If you're pleading the benefits relating to what will happen when the entire scheme has been put together and the later phases that could be some years ago, that's going to undermine your case and you'll struggle to make out your CPO justification. It's obviously also important to consider which CPO powers should be used. I'm focusing more on the regeneration powers, but do bear in mind that other powers are available. Housing Act powers, Highways Act powers, or even other bodies' powers, such as Homes England's. Don't jump too soon to identifying which powers are appropriate. You have to look at it, first of all, from the identification of the scheme and its purposes, because that should determine the objectives and specific functions that the particular body and those powers are due to, are meant to deliver. You are required to look at the most specific power available, rather than using a general one. So, for example, if you have a highway scheme for a bypass, you are likely to be using the Highways Act powers rather than the more general Town and Country Planning Act ones, unless it's being delivered as part of a wider regeneration scheme. You also need to look at the limitations of the particular authorising powers and consider what you actually need to acquire and whether it can be achieved by those powers. So, for example, if you need to create new rights, all you actually need is an easement, a right of access over somebody's land, then Town and Country Planning Act powers don't allow you to do that. You need to bring in the Local Government Miscellaneous Act powers as well. In some cases, you may need temporary working space. And note that temporary possession powers aren't yet in force for CPOs, so you've got to look at how that objective can be achieved within the relevant enactments. And bear in mind that if what you actually need to do is deal with restrictive covenants or rights to light, and the council already owns the land, then CPO is not going to help you because you can't compulsorily acquire those interests on their own. What you may need to look at instead is appropriation of land to planning purposes, which will then facilitate reliance on Section 203, the overriding of third-party rights in the Housing Planning Act. So a very, very big part of your justification, particularly with a regeneration CPO, is the planning position. And that has two different strands to it, really. First of all, does the scheme have planning policy support? But then secondly, do you have planning permission? So for a regeneration CPO, planning policy support is essential. The guidance is clear. You must have a clear strategic framework in place to justify the foundations for your CPO. There must be evidence base for it. It must have been consulted upon and should be as detailed as possible. So cautionary tale is to not promote a CPO prematurely without that clear planning framework in place. It can be a combination of an existing framework and an emerging framework, but provided that emerging framework has been through consultation and started to gather significant weight in the same way as you would take planning decisions. So it's important to have it in place to satisfy the tests. It supports the scheme which you're promoting. It can also help to resist non-compliant schemes, so you can object to planning applications by those who are seeking to deliver something else. It also has implications for when you're considering compensation for land that you're seeking to acquire. We're often asked, do you need to have planning permission in place before you promote a CPO? My answer to that will be no, but it's highly desirable. And the reason for that is you need to be able to demonstrate to satisfy the test that your scheme's not going to be blocked by planning permission or other legal impediments. And if you haven't got planning permission actually in place by the time you make your CPO, or certainly by the time of any inquiry or the decision, then you have a clear impediment, and you've got to be able to demonstrate there's no obvious reasons why planning permission won't come forward. And of course, you may have, for example, a resolution to grant planning permission, which is only subject to a Section 106 agreement. So that's likely to be more straightforward to demonstrate and evidence. However, if you've not got as far as that, and what you've got is an officer's recommendation to approve, then as we all know, that's far from the end of things, and members could go against the recommendation. So it's critical that your planning strategy and programme informs your CPO strategy and programme, and you don't make your CPO too early if you think there are going to be significant planning objections. The planning permission will also inform your CPO boundary, because you're looking to include all the land that you need to deliver your scheme. So it's having it in place ensures that you can demonstrate why the land is needed. For example, if somebody says you don't need that parcel over there, but you can show, well, actually, that's where the critical piece of open space is going to be delivered, and these are the impacts if that can't come forward. And it helps resisting in any competing schemes that are going to undermine that permission. So related to the planning point and impediments is deliverability and funding in general. The guidance is very clear. You have to show the scheme is unlikely to be blocked by any physical or legal impediments, including planning, but also any other consents and any works that may need to be programmed, such as infrastructure enabling works. So right from the outset, you need to look at how will your scheme be delivered? Do you need to procure a development partner? If so, where is that up to, and how long is it likely to take? Will it be in place before you make your CPO or before any inquiry? It's highly desirable for the developer, partner, or other type of partner to have been selected before you get to putting your evidence together, and even before you make the CPO. They will have a view on the scheme and what needs to be included. They will also be able to provide the viability and deliverability evidence and with confidence, and explain what they are doing to support that. You really want to have your contractual agreements with those parties in place before a CPO inquiry, because it lends that weight and support to demonstrating that actually, once the CPO and the land assembly is secured, that everything else should follow, and there's no reason why the scheme wouldn't be delivered. But be careful with your development agreements and joint venture agreements that they're not too conditional. And one of the example case studies I've got looks at an issue where it was found that there was not sufficient certainty that a scheme would go ahead, notwithstanding a development agreement. Consider what other consents are needed at the outset when you're looking at your CPO strategy. Do you need a highways order? Do you need to stop up land? Do you need other permits? These are things, particularly stopping up orders, that could hold up confirmation of your CPO until you have secured these other consents. Similarly, are there significant works that are needed before you can implement your scheme? So it may be that, for example, you need to put in a whole new new utilities, a major new substation, or there needs to be an improvement to the electricity or sewerage network, that's not directly under your control and is likely to be dealt with by the statutory undertaker. How are the things being coordinated? What evidence can you give to demonstrate it's reasonably likely that you will be able to achieve that and it will be in place to allow the scheme to go forward in a reasonable number of years? Early on, you need to identify whether you've got any special category land, because these can be significant delivery impediments, because you need additional authorisations and tests to be able to acquire land that forms part of special category. Open space, common land, allotments, statutory undertakers, national trust inalienable land. If you've got this land, you need a very clear strategy early on to ensure that you can overcome it or either avoid that land altogether if possible. And also be aware that Crown land can't be compulsory acquired. So if you've not got agreements with any Crown parties by the time of an inquiry, you need something clear that demonstrates that it will be forthcoming. You need statements of common ground, for example, with the relevant bodies. From a funding perspective, we're often asked how much information do you need to provide in order to demonstrate that the scheme is viable? That's quite difficult to define, but you've got to show that the necessary resources are likely to be available in a reasonable timescale. Reasonable timescale is not defined, but bear in mind that at the moment your lifespan of a CPO, once it's been confirmed, is 3 years. So if your funding is not going to be in place for 10 years, you know you've got a problem, for example. You've got to provide substantive information as to the sources of funding. You've got to explain if there are any gaps and how that's going to be met. So it may be that you need match funding. It may be that you need to go out for some equity funding. You're going to need to evidence how that's likely to be achieved. You may need letters of support and in principle letters from some of the parties that you are seeking funding from. You don't have to have all the money in the bank when you make the CPO, but you've got to have a very credible business case. And this is another reason why you want your developer partner with you, to show that this is something that they've got a tried and tested track record of doing. Human rights. So the next few tips really focus on the impacts on the people who are to be affected by your CPO, whether you're acquiring land from them or you're forcing them to relocate because they occupy or have tenancies. Inevitably, CPO will interfere with private rights. It's draconian. It's the very nature of the process. You're taking land away forcibly. So this comes back to that compelling case in the public interest test. Will those benefits outweigh the interference with individuals? And you've got to show that your interference is proportionate. So, for example, if all you need is a right of access, it will be highly questionable as to why you're putting the freehold of that land in the CPO. Human rights is something that flows through all public sector decision making, so it needs to be addressed at all stages of your process, both in scheme evolution, when you're looking at alternatives and the impact on parties at that stage, in your authority to make the CPO, your statement of reasons, which sets out your case for CPO, and then in your statement of case and ultimately your evidence to inquiry. And we'll come on to case studies where the impact on private rights has caused CPOs to be refused, and that can be the impact on a particular party can cause a CPO to be refused. Related to human rights, but a separate statutory requirement, is the public sector equality duty, which I'm sure, being your backgrounds, that you're very familiar with this. Public bodies and those exercising public functions need to have regard to the equality duty in the Equality Act. And ultimately, it's about eliminating discrimination and advancing equality of opportunity between persons with protected characteristics. There are 9 protected characteristics as set out on the slide, and it's something that you need to consider at all parts of the evolution of your scheme, the entire life cycle. You need to consider, for example, when you're looking at your scheme alternatives and site selection and route selection, whether that particular site will have a disproportionate effect on a protected group that you can't satisfactorily mitigate the effect. For example, are you looking to take away a key community resource for a particular group of persons whose protected characteristics? Can that be avoided? Can it be mitigated by re-provision and the like? And this needs to be thought about throughout your process. So I'd certainly recommend undertaking a qualities impact assessment at a very early stage and to keep that updated. It's certainly a fertile ground of challenge for all public sector decisions. Allied to this is meaningful engagement in negotiations, which in the first instance requires you to understand who you are impacting and what type of engagement and what type of strategy you need to put in place. So the guidance requires you to show that meaningful attempts have been made to acquire by agreement, but consider what meaningful is. I'm often asked, how many attempts do we have to make to try and engage? 2, 3, 10? How long do we have to negotiate for? 6 months? And my answer is, that's not the test, and that's not an appropriate measure. Really, it's you may have provided one particular person with meaningful information, attempted to negotiate with them, and they've said, go away, we're not engaging, full stop. You can't do much more with that person until they come to the table. However, you may be negotiating with somebody where you don't know much about their business, you don't know much about their requirements, and it's very iterative, and you've got to go through a much longer process with them. Importantly, you can pursue negotiations in parallel with the CPO process, but you do need to have regard to some of the best practice guidance that's in the CPO guidance. What you will find, and we'll see with one of the CPO decisions, is that inspectors are now starting to use that as a bit of a checklist of points. One thing that's important is to have consistency with deals. So you may have lots of people out there conducting negotiations, but ensure that you're not undermined by people saying different things to different parties. Ensure that decision making comes back to one point of contact. Look at who your priority targets are. That may be your special category land. It may be somebody that holds the core site that you need to acquire. Build that into your strategy. Think about different structures as to how you may negotiate with your deals, option agreements, sale and leaseback agreements, your relocation packages. And consider whether ADR may be appropriate to unlock where you can't get somebody to come to the table. But what's absolutely essential is that you keep very clear records of all of your engagement with these parties, including notes of phone conversations. They will likely need to be produced in evidence. And if you haven't got the records, you can absolutely bet that the objector will. And if you can't produce it to your barrister in the inquiry to say that what this person is alleging about the sufficiency of negotiations is wrong, then you can be in trouble. Related to that is, what's your strategy for mitigating the impacts of the scheme on these persons that are going to be displaced? It's absolutely essential, if you're affecting residents, to have a residential relocation strategy. You can have to go down right to the detail for individual parties if they raise objections at inquiry. So if you've got a residential relocation strategy, make sure there's some teeth to it. How is it bound in? How are you required to comply with it? What's the overriding objective? Are you looking to offer people the ability to relocate back into the scheme once the new housing has been provided? Are you going to facilitate people staying in the local area and not breaking up a community too much, which comes back to human rights and public sector equality duty? Bear in mind there's often quite an equity gap, the value of what you are acquiring from these parties, and then the value of the land and a new apartment that they may need to move into are likely to be significantly different. What sort of schemes and packages can you put in place to facilitate this? Will you look at discretionary purchase models and hardship schemes if people need to move early before the CPO is confirmed, but they need some advance funding to help relocate? And bear in mind also that as the local authority, you've often got the local housing authority obligations with additional requirements on rehoming persons. A particularly fertile area at the moment is how far your responsibilities and obligations go with commercial occupiers. So they may be your retail tenants in a shopping centre, as we'll come on to. They may be people occupying a business park, for example, an industrial land. It's increasingly important to have a clear strategy of relocation and assistance. But to do that, you need to know who you are trying to relocate, what their requirements are, what sort of timescales for moving, because you could have some very transient businesses that it's hard to get planning permission for because they're sort of dirty, bad neighbour uses, or certainly perceived as such. You could have somebody that's got some very, very bespoke equipment in their property that has to have continuity of trading. So I've been involved in a scheme where we had to, it was a printing press and they couldn't halt it. So you had to ensure that the new premises were up and running and a replacement set of printing press was available before they closed down the previous one. That's got a long lead in, has a huge implications for compensation, but also your timing and program for acquiring the land. So these things, it's really important that early on you understand who you're dealing with and their needs. You can provide things such as assistance with finding relocation opportunities. Some authorities even purchase land or offer sites that they already own, but make sure if you do that those are actually suitable for the needs of the parties that you're affecting. Consider also allowing CPO compensation to be released early, advance funding, so to speak, to fund that relocation, which ultimately, it's mitigating the impacts on them and probably mitigating the overall compensation package if they can move at a time that best suits them, rather than right at the last minute once you've implemented your powers, and they could have increased costs. And finally, the last tip really is to acknowledge that CPO and these projects are, it's huge. You've got a huge number of parties involved in it and key stakeholders, not just within the particular authority, but also you'll have planners involved, you'll have viability experts, you may have a retail market expert depending on your scheme, housing officers, lawyers, barristers. You need to know who your core team is, and you need to keep it tight, and you need to keep your communications tight. If you've got too many people out there having different conversations and inconsistent conversations, then that can be undermined. So clear roles and responsibilities and leadership, clear project plan, sharing of information, looking at core messages, consistent messages as well, right from the outset, being very, very careful about making commitments that can't be adhered to. And I'll come on to a case study that looks at that. But if you're going to make commitments, you need a clear way of recording that and then following it through. Have a commitments register. You'll often be giving undertakings, so ensure that you're monitoring those. Try and have a core group of people that can make decisions. Keep all records. Again, that's essential, but also bear in mind that you are going to face repeated FOI requests, environmental information regulations requests, GDPR. because those who oppose the scheme will use every tool available to seek to frustrate and delay matters, but also get information that they consider that is necessary for them to make their case. And you need to ensure that how you have been recording information is in a way that you are happy ultimately to be disclosed, or has an eye on the risk that it would be disclosed. So that's the top 10 tips. We'll now have a look at some case studies over the years of CPOs and issues that have arisen in CPOs. The first one is a reasonably old scenario from 2010. It's the London Thames Gateway Development Corporation Bromley by Bow CPO, where the key issues were deliverability and business relocation. This was a two-phase scheme. The first phase was very advanced. Tesco, you had detailed planning permission. It was quite clear what was going to be delivered. Phase 2 was less advanced, and Tesco were not bound to deliver it, and there wasn't another developer on board or funding identified. It was accepted that there was a need for the scheme, that regeneration benefits would occur, but the CPO was still refused. And there were two main reasons. Firstly was the particular impact that the CPO would have on a major employer in the area, a nationwide scaffolding firm. That employer provided a huge amount of quality and quantity of jobs for that particular community. So it's it's human rights, it's public sector equality duty coming in as well. And whilst everybody always pleads the new employment opportunities that will come from a scheme, in this case, the Secretary of State found that those opportunities did not override the type and the numbers and the quality of the jobs that would be lost in this case. It was also refused because of a failure to demonstrate the realistic prospect of the scheme going ahead, particularly the second phase, because of that high conditionality and nobody being bound to deliver it. So comes back to, if you've got a multi-phase scheme, consider the scope of your CPO. It may well have been on this case that if it had been phase 1 only, it may have succeeded, subject to understanding the implications for that particular occupier. The next one is the Aylesbury Estate CPO, which was made by London Borough of Southwark back in 2014, which principally engaged human rights and public sector equality duty. This was a estate regeneration scheme, housing estate regeneration scheme. The very old sort of style housing blocks in London that was going to be replaced by something of much higher quality, 830 new homes that were fit for purpose. It seemed to tick all the main box, complied with planning policy, lots of public benefits. It was viable, developer in place, and no impediments. And they had very few properties left to acquire by the time they got to inquiry. But the focus ended up being on one particular resident. And evidence was put forward of what this particular resident would have to do to relocate. There was huge issues around the equity gap position, and effectively the Secretary of State found that the public benefits did not outweigh the impact on leaseholders' rights, and therefore the compelling case in the public interest failed. Now, what then happened is the council challenged that decision, and ultimately the Secretary of State consented to judgment because of how really around the public sector equality duty tests. And there was a reopened inquiry and that CPO was confirmed, but it does show that if you have these individual issues, or if you have public sector equality issues, then you can end up in delays. You can be used as a tool of objection, and you can absolutely guarantee that those who are writing those objection letters will cite the Aylesbury position, even though it was ultimately overcome. That's not to say, though, that you can't still secure your CPO if you've got impacts on residents and those with protected characteristics. And that's what happened with Brent Cross Cricklewood. So these are orders which were actually confirmed despite impacts on public sector equality duty. So what happened here this is a big comprehensive scheme, a major opportunity area in London, part of which required the acquisition of residential units in various towers at an area called the Whitefield Estate. The inquiry was held, but then the Aylesbury Estate decision came out, and so there was a huge amount of post-inquiry correspondence passing between particular objector, the acquiring authority, and the Secretary of State, because the inspectors had closed the inquiry, on dealing with equality duty matters post Aylesbury Estate. Now, the council had a very comprehensive residential relocation strategy that was secured by planning condition and lots of various measures and mitigation packages that were in place. And effectively, the Secretary of State endorsed what the council had done here. Collaboration with residents, an independent residential advisor was appointed, a steering group, consultation, sharing of information, relocation opportunities. And all of that meant that the Secretary of State was able to write up in an effective way what the public sector equality duty impacts would be. And the Secretary of State acknowledged that there were some, and that the protected characteristics of age and disability and the displacement from the community of those particular objectives would have negative impacts, but that this would be mitigated. And whilst it wasn't possible to mitigate these impacts entirely, because you are displacing people, ultimately these impacts couldn't be mitigated in any other way by modifying the scheme, and the public benefits still overrode the impacts on those parties. So it is possible, and if you've got equality duty issues, and it's useful to have a look at this decision as to how the Secretary of State dealt with it there. Touching on some of the business relocation and also viability issues, we've got two reasonably recent CPO refusals. First one being Vicarage Field CPO, and both of these actually involve the demolition of existing dated shopping centres, which I think a lot of towns have got, and trying to repurpose it for mixed uses. But both were refused in some way for similar reasons. So on both of them, the inspector accepted that there was a need for the scheme, that there'd be transformative change, and that planning policy was there, there'd be huge benefits. And on Vicarage Field, there'd be an extremely compelling case for acquisition. But the main reason the CPO was refused was because the inspector was not satisfied that the scheme was viable. There were high occupancy levels of the existing shopping centre. The budget that had been built in for the council's compensation, it transpired it didn't include business extinguishment costs, despite a need to have to deal with relocation and risk extinguishment. But more importantly, it came down to the particular viability appraisal. The developer was reluctant to present a viability appraisal to the inquiry due to commercial sensitivity. And what then happened was the objectors found that there had been a viability appraisal that was conducted previously, 5 years previously, as part of the planning application. And that found the scheme to be substantially unviable, no doubt because it was looking at the amount of affordable housing and other planning contributions at the time. But this and the lack of concrete evidence about future commercial occupation of the scheme meant that the inspector could not conclude that there was a reasonable prospect that the scheme would be delivered. There was an additional ground of refusal that related to the attempts of negotiation. And what the inspector did was they went through that guidance in paragraph 19 of the CPO guidance and looked at whether the acquiring authority had followed all those various tests. It's not clear whether those reasons would have caused the refusal in its own right, but I think it compounded it as did the fact that this had been a scheme that had been quite stop-start, I think, over the years, with engagement going back to 2015, and also quite a lot of delays from when the CPO was authorised to be made and it actually being made. The Nicholson's Shopping Centre CPO, which was refused in January this year, again, another outdated shopping centre. It complied with all the various planning tests and benefits. This time it was financially viable and free from impediments, but the focus was on one particular landowner that would have to relocate, and this was a nightclub, Smokey's nightclub in the town. Evidence was given by the objector that it was likely that they'd need to cease trading. This caused the inspector great concern. The other negotiations and the way the acquiring authority had gone about things were found to be compliant, but the possible extinguishment of the nightclub was a huge problem for the inspector because they felt that it would have a significant adverse impact on the town, on the staff, on the customers, but also looked at the severe mental and emotional impact that it would have on the owners. And the owners were saying there was no suitable relocation premises that were offered. I wasn't involved in this, but having read the report, there are 7 pages of the inspector's report going through the negotiation history, both before and after the CPO was made. So it's absolutely clear relocation premises were offered. The acquiring authority did quite a lot, but what was the sticking point was whether a smoking area could be accommodated. Financial terms couldn't be agreed, which is often the case. That shouldn't be a reason not to grant a CPO. But what happened was the acquiring authority, as is quite usual, increased their offer quite significantly just before the inquiry, which the inspector then took as meaning that any earlier offers weren't realistic and therefore hadn't been genuine engagement. So the inspector felt that Smokey's nightclub it was not unreasonable for them to have a like-for-like replacement facility with a smoking area, and therefore the scheme benefits did not outweigh the impact on the club. I have some challenges with how the inspectors got about that, because there's not a requirement in law to provide a like-for-like replacement for anybody that's being acquired. And I'm not surprised that the decision has been challenged, and I understand that's due to be heard in the High Court very soon. So watch this space on that one. But what it does show, and what Nicholson, the previous Vicarage Field one, show, is this increasing importance on your engagement with affected parties and what you are doing regarding business relocations. Last case study, a very short one. This comes back to the communications point, this is a case that arose out of housing renewal CPOs that Sefton were doing back sort of in 2007, 2008. Belfield's own land within the CPO boundary that they wanted to develop themselves and said should be excluded from the order. The objection failed and their land was included in the order, but one of the council officers made a commitment to them in an email that said, if you can develop your own site in accordance with the planning policy for the area in a timely fashion, then the council would see no requirement to acquiring the land by compulsion, despite the ability to do so. Belfields then relied on this and thought that they would retain their land if they developed in a timely fashion. They went away and spent more than £1 million working up their proposals. So when they then received a general vesting declaration, they challenged it by way of judicial review. And the High Court found that that email from the council officer was clear, unambiguous representation, that it was reasonable for Belfields to rely on, and a legitimate expectation that their land would not be compulsorily acquired. So it's a cautionary tale really for acquiring authorities about commitments. Be careful who is saying what. ensure people are authorised to give commitments and track them and actually carry them through, because you could end up in court. So final brief section, just for the last 10 minutes before we go to Q&A, is really just touching on law reform. And there are proposals in the offing at the moment in the Levelling Up and Regeneration Bill, which has a section Part 9 on compulsory purchase. Quite a lot of the proposals are procedural, and a few ad hoc points that have arose, I think, from various schemes. So one is an ability to agree to vary the vesting date by agreement if it's helpful to allow somebody to stay that little bit longer. There are reforms to do with certificates of appropriate alternative development, which is where somebody seeks a certificate from the planning authority that, had it not been for the CPO, they could have secured planning permission for another use, which informs their compensation. There's confirmation that Section 2261A CPOs allow our regeneration CPOs effectively. Various online publicity requirements, which are very helpful to modernise processes around written representations and hearings rather than have to go to an inquiry, and a process to seek a longer power period in which to implement your CPO. So it's currently 3 years, and I think they're probably looking at 5 years, which is more in line with development consent orders and Transport and Works Act orders. And I think it's very sensible, given these major projects. 3 years is quite a tight timetable to get everything ready before you want to actually acquire the land and trigger compensation liability. One of the more interesting points in the bill is a proposal to be allowed to have conditional confirmation of CPOs. This, I understand, there's not much detail because the detail will come in regulations, as is often the case, but it could mean, for example, that a Secretary of State could say, they're minded to confirm the CPO, provided that a particular condition is satisfied. That condition, there's no guidance as to what the government has in mind, but it could be, for example, ensuring that you have got your stopping up order granted, and then you can discharge the condition. It could be related to obtaining funding that's not yet in place, or securing your development partner. These are just scenarios that I think may be possible. You have to seek a discharge of the condition formally from the Secretary of State. You have to allow affected parties to make representations before that condition is discharged. And I suppose that then possibility of some reopened inquiry or other form of hearing in order to satisfy human rights and rights to a fair hearing, etc. So I can see that it could be useful in some scenarios, but you do have to consider if you're seeking a condition relating to funding, you've got to question whether your order was made prematurely before you had your case together. But the topic that has engendered the most debate is land value capture. This was consulted on by DLUC back in June 22, and ultimately amendments have been introduced to the LURB in the House of Lords as it's passing through Parliament. And what the objective is to allow a capping direction that in certain CPOs and only schemes that involve affordable housing, health or education, there can be a direction that there shall be no compensation based on the prospect of securing planning permission for another use or the hope of securing planning permission for another use. So essentially, unless you've got an actual planning permission in place with clear value attached to it before your CPO is made, then any latent development value or hope value that you may otherwise have had will not be compensated for. You'll be compensated in its existing use, and then the monies will be channeled into the affordable housing and other public sector requirements that facilitate the scheme. Only certain bodies can seek a direction. That includes Homes England and local planning authorities using the Regeneration CPO powers. Obviously, you've got to be able to justify this. So there's a statement of commitments that will be required to seek your capping direction alongside your CPO. How much detail you've got to put forward, I think there's a real risk that you could have to have detailed liability evidence, opening your books effectively to justify why you need to capture that compensation that somebody would have already had and to feed it into the scheme. And obviously you've got to have engagement on it, otherwise you fall foul of the human rights regime. So I suppose the scenario is you've got greenfield land, agricultural use, you've got emerging planning policy that would allow some development. So somebody hasn't got actual planning permission, but has a hope of securing planning permission for something other than agricultural uses in the future. If you've got a capping direction, then that person will not be compensated with on the basis of the hope of that alternative use, but will still just get the existing agricultural value. This has caused debate due to the fundamental principles of equivalence that flows through compulsory purchase compensation and whether this offends it. I think we are going to get quite a lot of challenges around this, and the devil will very much be in the detail and on the justification for the direction on a particular scheme. I think it's feasible that it could cause delays to schemes. It's another ground of objection, but equally if the direction is successful and passes through without further legal challenge, it could accelerate delivery, because of course you're capturing money from the existing use that you would have otherwise had to pay as compensation, and you're directing it to affordable housing, health, education, etc. So that's the overriding aim. But I think there will be quite a bit more debate around this before we see anybody actually seeking these directions, if it comes in this form through the LIRB. And that's really the end of my session. That's the general update. So I will stop sharing my slides, hopefully, if I can get the tech right. And I was
going to say, I suspect you need a drink, don't you, Michelle? So I'll do some filler while you get yourself back together. That was a tour de force of CPO there. So very well done. Normally we have a panel of speakers, so well done you for keeping going. So I've been sort of collating a number of questions. Just a couple of things I would like to say is that obviously Michelle is not a valuation expert. She's not a surveyor. And so I think I'm not going to pose any more of the valuation-based questions to Michelle, but I would be very happy if you wanted us to perhaps come back to another programme and do a session specifically around valuation matters. If that would be useful, let us know in the chat. Also, what I would like to just say is that in terms of the legislation that is going through at the moment, I think the key is let's wait and see what pops out of the other end of the sausage machine. And the devil will be in the detail of the guidance that DLUC will essentially put alongside the legislative changes. So don't assume that any of these things are in place at the moment when you're planning your schemes. Be mindful, but they are not enacted in law just yet. And what I was going to just add as well, while Michelle just takes another breath, is that I know that DLUC, we are working alongside them in looking at setting up a library of compulsory purchase orders and sort of a template library as well. And so this will be a repository where you guys that are looking at CPOs can go and maybe search on different types of CPOs and what are appropriate templates and forms of things to essentially be submitting with your orders. So are you suitably recovered, Michelle, to launch into the QA?
I think right. So. Let's go for it.
We'll do questions until about 25 past, if that's okay. So the first one, which was very popular, excuse me, reading my notes here. In terms of evidencing funding for CPOs, obviously we evidence, the costs, but in terms of the consultants and the legal costs, does that also have to be funded? To which I'm guessing, yes, it probably does, as well as the development costs. But then how much detail needs to actually be displayed about those costs? And is that FOIable?
So it's still slightly croaky. In particularly, yes, they could be FOIable. I'm not an FOI specialist, but you can, obviously, in certain scenarios, resist disclosure of matters that would prejudice the public body's objectives from being delivered. But what I would normally say is you wouldn't normally present your full appraisal. What's you want to do is explain that you have a pot of however many millions, usually, not just for my fees, but that you've taken professional advice on the estimated compensation liability, explain the types of heads of compensation and what you've had regard to, but not, of course, listing out what you have allocated for everybody's party, every particular person, because of course that's going to undermine your negotiations with that party if somebody gets hold of it. So that's your starting point. You would explain that you have made appropriate allowance for your procedural costs of promoting the CPO and for your entire consultant team, as you know, and their costs in it. So you wouldn't normally go down to the granular detail of the individual items, but you want to demonstrate that what you've done is in the right ballpark.
Okay. What I would say is, if we do a valuation session later on, if there is enough groundswell of opinion that's required, we will actually go through some example costs in terms of how much your legal fees are going to be if there's one objector versus 4 days of fully tooled up objectors for 4 days, and it's very long and drawn out.
Yeah. I mean, what I would just say, Claire, is that the focus is rarely on the process costs, because actually the CPO process costs, whilst still considerable for the public sector, that's usually a drop in the ocean compared to the cost of delivering. And the compensation. So the focus is normally, have you made appropriate allowance for compensation, including taking account of business relocation needs, but then separately is this a scheme actually going to be delivered? Because what's the cost of actually bringing it forward? What's your high level appraisal? And that's where you really want your partner to stand by you to explain what they've taken account of.
Yeah, excellent. So another interesting question that came up: does CPO law distinguish between consultation and engagement, which are of course two very separate things?
No. Well, I suppose what you find that the consultation is iterative. Some of that will be undertaken as part of your planning process. So you will, in your evidence, be explaining consultation, not on the CPO, but on the scheme evolution. So I suppose that is a slightly different concept. Engagement is more about your negotiations, your attempts to acquire by private treaty, and what has been meaningful. So there's nothing enshrined that in law, but necessarily these things are slightly different, but often end up merging together, because if you're having early discussions with affected parties, they will be talking to you about what the scheme looks like, how it's going to affect their land, and seeking changes potentially, as well as what their potential compensation could be.
I mean, it's very much best practice, and the word of advice I always give to people I speak to about CPOs: make sure you engage professionals if you're not sure, because it is a very tricksy ground and you can get tripped up very, very easily. So another question: telecoms relocation. apparently they're an interesting group of people to deal with, as we all know. In terms of the actual equipment that you are relocating for telecoms providers, do you have to provide like for like? Because some are looking to upgrade. I think you've already mentioned this in passing, that like for like technically is not enshrined anywhere.
It's not, but what you've got to bear in mind is the protection that telecoms code operators have.
Yeah.
As well as other statutory undertakers. So the telecoms, that you've obviously got the telecoms, the Electronic Communications Code, which you can follow, but then there's also provisions in the Town and Country Planning Act, off the top of my head, round about section 270, which you cannot go and forcibly remove their kit, their apparatus, without going through various processes. So it's going to be a negotiation with the relevant telecoms operator or statutory undertaker. They may well want to improve and upgrade what they do on any diversion, because what you can't do is just leave them with a gap in their network. But if they want to upgrade, then that's part of the negotiation, and saying, well, that's not equivalence. They should bear the costs of anything that is over and above ensuring effective provision. But I recognise that that is a challenging position, and often concessions are made.
I was going to say, in terms of improvements, as you say, it is a negotiation, and sometimes to get them on board, it might be easier just to look at the route of improvements. So yeah. Also, interesting question. Have you ever known any examples of CPOs purely to deliver public realm?
Yes, in a roundabout way. The CPOs, the CPO that was made in Ancoats in Manchester, going back a few years, by Northwest Development Agency, when we had the RDAs in place, that's an area of old historic mills, and it comes back to what your scheme is and what you're seeking to improve, and what the authority's role needs to be in facilitating it. And key to that was public realm, high quality spaces and connections. And so it was very much promoted on the basis that the authorities needed to control that, to create the right place for regeneration to then happen. They then had sort of implementation agreements with a lot of the building owners, so that whilst these buildings were in the CPO, it would be backed up by an agreement to actually allow the individual parties and building owners to redevelop themselves. But what was critical and developed and led by the authority was public realm. So I'm not saying it's not straightforward, and you've obviously got to look at the very specific circumstances as to why that public realm is necessary, what benefits flow from it, why that type of public benefits, why that type of public realm, and what will it do, and what's the implications if you don't get it. So it's a challenging position, but in the right circumstances, it should be capable of being run.
And it comes back again to the thing that's important is the scheme, not the CPO. The CPO is the tool to deliver the scheme. Yeah. Okay. In phased CPOs, does the initial phase need to be viable in its own right, or can it rely on the wider scheme?
Well, it depends what relying on the wider scheme means, because yes, in principle, it's got to be viable in its own right, because if it's first phase, you assume it's going to be delivered independently of the rest of the wider scheme. So if you're using the wider scheme to leverage in some form of match funding that then allows you to deliver the first phase, then I can see why there'd be a link, but you'd have to show why that's likely to come forward. But in principle, you look at your red line, you look at that scheme, and you ensure that you can meet all the tests based on that particular phase, and not the rest.
And I think it's also fair to say that a delivery strategy is very much required to sit alongside a lot of the other work within CPO, so that when the Secretary of State gives consent, there is confidence that it will actually be delivered as well.
Yeah. Now, it may be that your overarching funding strategy allows you, because I seem to recall that on Brent Cross, for example, that some of the funding was coming from, and this is not my specialism, but was coming from effectively the increase in business rates that would come. So it was coming forward and was evidenced as to how it would happen. But obviously that increase hasn't happened at the time. But it comes down to your grant funding agreements with whomever's actually providing that.
Yep. So here's an interesting one. Do you have to have your relocation strategy in place, ideally, before you apply for your planning permission?
Ideally, yes, because actually you are likely to have to, well, certainly Brent Cross, it was conditioned as part of the planning permission, because it's part and parcel of your public benefits and the disbenefits and the planning balance, as well as your CPO balance. So if you have not developed it, or at least got to early drafts and have not got a clear idea as to where you're going with it, then it's going to impact on your ability to secure planning permission, because questions will come from it. So yes, it needs to be thought out as a very early stage, including planning. But I can't say it's essential, because every scheme will be different and it may not be as big an issue.
But I suppose if you don't get it organised, you're looking at impediments to your planning with sitting tenants who are going to be difficult to get rid of, and that would be taken as a view by the inspectorate, I would imagine. And where affected, this is a classic CPO question. So where affected landowners have a viable scheme of their own that they say it is viable, but they have no intention at all of implementing the scheme. They're just purely doing it to frustrate the acquiring authority. How would you overcome that? What tactics would you use to overcome that?
Well, first of all, you've got to look at who are they? Have they got track record of being able to deliver these things? Where is the money coming from? All of these sort of responses to objections, to question and challenge what they are actually saying. And also you've got to look at the compatibility of what they are proposing with the scheme. If it doesn't comply with planning permission and planning policy, and if it's fundamentally going to put a great big hole in your scheme, then there are other reasons that you would put forward as to why that is not a proper alternative and shouldn't be treated as such. If it is a credible alternative, and if it will advance the objectives of your scheme and planning policy, that's when you then might start looking at putting in place some form of agreement with that party, backed up by retaining the CPO powers in the background, but giving them clear milestones to ensure that they actually deliver, but with the ability to step in if they don't.
And I guess the other control, it comes back to the planning position as well, in
Planning
terms of
well,
the overarching, placemaking and quality, aspirations for the scheme as a whole. They have to be able to demonstrate that their scheme would, coalesce with the SPD or whatever is in place.
Absolutely. It's sometimes if you've got a comprehensive overarching planning framework, it can be hard. That doesn't require sort of single development, and it does allow things to come forward piecemeal, then they may actually be able to demonstrate that it can comply, but it doesn't mean to say that it ever be delivered. But we've certainly been involved in a number of scenarios where agreements have been put in place with landowners of that nature, that holds them to task, but also makes sure that if they fail, that you can step in with the CPO, because obviously you need a fairly tight timescale if you've only got 3 years for them to show that they're going to deliver.
And actually, timescales, we were asked at the moment, what's the current timescale to get to Lands Tribunal if negotiations fail? Any idea how quickly they're running at the moment? In terms of valuation?
I suppose there's a number of issues there. Firstly, who's going to make it's when will somebody make the reference? But let's assume that somebody puts a reference in. Depends how big a case, but I would say you're probably not going to get a hearing within about 9 months, unless something gets vacated. That doesn't mean to say that you can assume you've got 6 months to deal with all your evidence. What the tribunal is doing is issuing directions fairly early on to require the parties to front load everything, even if you've then got quite a big gap between the evidence and the actual hearing. So yeah, that's a pure rule of thumb, but yeah, the Lands Tribunal only has finite resources.
I'm afraid it does. And in terms of the public interest test, does that include protection of listed buildings? Now, obviously, there are different compulsory purchase powers within, listed building legislation, but could you generally include protection of a listed building within a public interest test, do you think?
Yes, as part of other reasons.
Okay.
Because if you're solely making a CPO to protect a listed building, then you've got to question your powers and look at the powers to, under the various listed building legislation rather than Town and Country Planning Act. But it is often the case that in the wider comprehensive regeneration schemes that you will have some listed buildings, and part of preserving them and bringing them into viable use is part of your benefits, environmental, social well-being benefits as well, that the scheme will facilitate. But you've got to look at, what's the scheme, what's the choice of powers, and then make sure you've met the test in the context of those particular powers.
So I'm going to make a silly, well, it's a question here because there's no such thing as a silly question. How early on do you need to decide which powers are appropriate? Or essentially, do you work up your scheme, your delivery strategy first, and then retrofit it afterwards?
You're looking at your scheme and the objectives and the appropriate tools to deliver it before settling on powers. Yep. Which it will be done in conjunction with the various local authority stakeholders and also the lawyers to make sure the powers can actually be done and can actually be met. So what you'd probably have is fairly early CPO strategy workshops that go through a lot of those top 10 tips points, and that flushes it out. It's where you get, you are looking at what actually are you trying to achieve, and is the appropriate power Town and Country Planning Act, or is it something more specific under the listed buildings regime?
I could see your presentation today being made into the checklist for these CPO strategy workshops, and the people will be using them for years to come. So I think
that would be great.
Well, as long as you get some IP on it.
Yeah, it's not surprising that if we're asked to advise on CPO strategy, those are the questions that immediately need to be teased out before you can put together something suitable and steer the case in a particular direction.
So I think we've got time for just a couple more. So somebody said, I think that one of the failed CPOs included a delay of 3 years between resolution and making orders. What period of time between resolution and making orders do you feel is reasonable? If this would prejudice you, don't answer.
No, it won't. I mean, I don't know the detail as to why there was such a delay on that one. I think it was Vicarage Fields, wasn't it? But as with any decision making, if in a planning sense, if you've got such a delay from when your cabinet or whichever authority took a decision, even on planning permission, you take it back to committee. Circumstances may have changed, but I would normally look to take the resolution to make the CPO and make the CPO fairly swiftly thereafter, not least because your resolution to make a CPO is capable of being judicially reviewed. You don't want to end up in separate litigation on that. You want the route of objection and challenge to be through the order itself. That's your ideal. You would wait. You would have it set up so that once you've got that resolution and you've got past any challenge or scrutiny period, you go fairly swiftly into making your order. Doesn't always happen that way.
And a more, I mean, you've touched on this in your presentation, but which do you think is most difficult, acquiring and relocating residential properties or commercial properties? Or is it just two sides of the same coin?
I suppose residential gets heightened attention, brings in the human rights, it brings in equality duty, And so I would say that needs greater focus when you've got residents, and obviously you can the nature of the objections you will receive, but what you cannot forget the commercial occupiers. That's the key messages coming from it. But you do tend to focus more initially on the residents. These are people's homes.
Although post Smokies, who knows?
Well, that's the challenge, and it's how far do you go. Somebody asked, should we be buying up land to relocate commercial occupiers? And that I would ordinarily say not necessarily, but then some schemes do it. If they know that they've got to relocate a lot of people in a short amount of time. Take the Olympic CPOs, for example. Land was bought, industrial estates were bought to be able to move people in, but that was probably quite a specific situation, and it really depends who are you displacing.
Yeah, sure. Well, you'll be pleased to know that you can now sit back and relax, have a gin and tonic or a coffee. If you'd be so kind as to share the final few slides, and I'll do the wrap up. I have to say you're getting very big love in the chat, which I know you can't see at the moment, but you can go back and glow and bask in the love later on. So thank you so much, Michelle. So these slides will be shared. So the sort of the précis there of what we hoped were the top tips will be shared with you. So I think we're 3 minutes early, but I am going to just draw that to a close. So thanks once again to Michelle. Thank you to everybody for your time in attending today. And if there is enough demand, hopefully we will run another CPO session again in the future. Thank you all. Goodbye.
Thank you. Bye-bye, everyone.